now and press the bell icon. Never miss an update.
Suppose A murdered B. So A himself is saying those, confessing them. Suppose I saw this incident. I am like being a witness of this incident. Yes, I saw A murdering B. So this will be the direct evidence, but directly bringing out the guilt of the accused. Indirect evidence is an evidence which points to the guilty. Yes, meaning that yes, the accused may be guilty. There's not full proof conclusion over there. It just points out, yes, ki this suppose A murders B. This is an example. And before A went to the house of B, A said to me कि यार B ने बहुत परेशान करके रखा, आज तो मैं उसका काम खत्म करके रहूंगा. Suppose this is what B says to me, like I depose before the court that A said this is this to me. So what I'm telling to the court right now will be an indirect evidence, because I'm pointing towards guilt. My evidence, whatever I say before the court, will not be a conclusive proof of the guilt of the accused. Is the difference clear between to you all? Direct evidence and indirect evidence.
Yes, ma'am.
Clear? Okay. So circumstantial evidence. What is the circumstantial evidence now? Circumstantial evidence is nothing but an indirect evidence. What happens over here in circumstantial evidence, different sets of evidence, you can say, they are clubbed together to form a continuous chain which shows that yes, the accused is guilty of such and such offense. In that case, each and every evidence, if you take it individually, will not be able to prove the guilt of the accused. But when all the evidence are combined together in a chain, they're able to prove the guilt of the accused. So this is the basic law you need to remember for this case. First, circumstantial evidence, and rest I will discuss in the main course. So coming back to the facts of the case, the accused was charged with such offences and he was sentenced to death by trial court. The sentence imposed by the trial court was confirmed by the High Court also. Now on the appeal to Supreme Court, there were three basic issues were framed with the Supreme Court. First issue was whether the non-recording of a disclosure statement of the appellant in the language which is not known to him, whether it will prejudice to cause of justice or not. I'll explain to you this. Here, what happened? A disclosure statement was recorded of the appellant, but the language it was recorded, in which it was read over to him, was unknown to the appellant. So, whether that disclosure statement holds evidentiary value or not, this is the first issue. Second, whether DNA evidence can form solitary basis of determining the guilt of the accused. In this case, under Section 53 of CRPC, we will read further now. The DNA evidence was taken. So whether the DNA evidence can be what evidential value the DNA sampling holds, and can it be a sole basis for determining the guilt of the appellant or not? This was one other issue. And third issue, which was the broader issue of all, whether the circumstances identified and relied on by the prosecution indeed point to the guilt only of the appellant, closing out any other possibilities, meaning there but all the circumstances clubbed together do they point out to the guilt of the appellant or not. So till here, any issue, any problem, anything you want to ask?
Ma'am, please repeat the issues once.
Am I audible now? Please confirm.
Yes, ma'am.
Sorry, there was sudden power cut, so I need to switch on my Wi-Fi and whatnot. Okay. Till what I was saying, like till when you could hear me?
Ma'am, I asked to repeat the issues once so that I could remember them.
Okay. So three main issues were there. Firstly, the broader issue, like the main most important issue of this case was whether all the circumstances that were identified as proving the guilt of the appellant, whether they are in totality prove the guilt or not. First, second, the DNA evidence that has been taken of the accused, whether it can be the sole basis of like determining the guilt of the appellant. Can that only be the criteria for like proving the accused guilty of such and such offense? And third, whether a disclosure statement that was recorded by the appellant and the language it was not known to the appellant, whether such disclosure statement holds value in the eyes of law or not. So is it clear now?
Yes, ma'am.
Okay. So continuing further. So these were the issues. So first I'll discuss to you with what is circumstantial evidence and what court said. Please note whatever I have marked in red color is the passage taken directly from the case, and this could be a part of the question that can be asked to you. Like the examiner can just pick up these lines, and on basis of these lines only they can frame a question to you. So please note that these parts are very important to you for you to remember. So for circumstantial evidence, the court said the law on circumstantial evidence is well settled. When a case is covered by such evidence, the evidence must point singularly to the guilt of the accused of the appellant, closing out the possibility of all other hypotheses. Meaning over here is this, that suppose there are 5-6 evidences. First thing important is each evidence taken individually cannot prove the guilt of the accused. Suppose in the previous case of only A but B, A said to me before going to the house of A that I'll do this to B. So can this evidence can prove the guilt of A? No. So each evidence individually cannot prove the guilt of the accused. But when all this evidence is like, suppose some other person saw him approaching B with a gun, some other person saw a scuffle between A and B. So all 3-4 persons deposed that yes, we saw A and B involving such and such incidents. If all this evidence are taken together, then if they point out to the guilt of the accused, they will help with circumstantial evidence. But the important thing over here is that they must point singularly to the guilt, means all the evidence must prove guilt only, nothing else. There should not be a point iota of doubt, like कि suppose कि ये हो सकता है, ऐसा नहीं होना चाहिए. Direct evidence नहीं है, but indirect evidence should be conclusive proof, similarity to the guilt, and closing out the possibility of all hypotheses, means only this hypothesis what prosecution is claiming should be the hypothesis that can be formed by dotting all these evidences. No other hypothesis can be possible. Means suppose I will explain again in Hindi. हमने सारे एविडेंसेस की डॉट्स कनेक्ट किए. मैंने जो सुना, किसी और ने जो सुना ए बी को करते हुए, किसी और ने बोला, उसके डॉट्स कनेक्ट करके एक ही हाइपोथेसिस बननी चाहिए जो प्रोसिक्यूशन क्लेम कर रहा है और जो प्रोसिक्यूशन प्रूव कर चुका है बियॉन्ड डाउट. Is this clear? What is circumstantial evidence? Clear?
Yes, ma'am.
Okay. So this is circumstantial evidence. The most important case, or you can say the first case for circumstantial evidence, is Sharad Virdichan Sarda, State of Maharashtra. If the examiner is framing question on this part, circumstantial evidence, they will definitely ask this case. So this is the most important part of the case, which was also mentioned in the Prakash Nishad case. The circumstance should be of definite tendency mind the words definite tendency, unerringly pointing towards the guilt of the accused. Means no other possibility, no iota of doubt should prevail over there. Circumstances taken cumulatively, not individually, cumulatively all together, should form a chain so complete that there is no escape from the conclusion that within all human probability this crime was committed by the accused, and they should be incapable of explanation of any other hypothesis that the guilt of the accused and considered innocence. I explained you. So two things here to remember: definite tendency. Secondly, cumulatively should form a chain. This is what two principles of Sharad Vidyachan. Then two recent cases, Indrajit Das, State of Tirupati. This case was also referred by the Supreme Court, and the Shailin Rajat Paswan, the State of Gujarat. Here, twofold requirements were laid down for this circumstantial evidence. First, that every link in the chain of circumstances necessary to establish the guilt of the accused may established by the prosecution beyond reasonable doubt, meaning that every evidence, suppose what I suppose in the previous example only, what I had said, what other people are other witnesses are saying, all these evidence must be individually proved by the prosecution beyond reasonable doubt. ऐसा नहीं कि सबको मिला के को बियॉन्ड रीजनेबल डाउट प्रूफ करना, नहीं, हर एक एविडेंस को, हर एक विटनेस को, उसके एविडेंस को इंडिविजुअली प्रोसिक्यूशन को प्रूफ करना बियॉन्ड रीजनेबल डाउट. First thing. Secondly, all the circumstances must be consistent, pointing out only towards guilt of the accused. Whatever circumstances, whatever evidences, incidents the prosecution is referring in this chain, all these circumstances must be pointing towards the guilt of the accused only and nothing else. Means suppose in this case, suppose only जब A ने मुझे बोला कि मैं B का कांच पता करके आऊंगा, फिर A ने साथ नहीं बोला, बट नहीं इतना भी मैं उससे गुस्सा नहीं करूंगा, ए अभी की सिचुएशन अभी अच्छी नहीं चल रही है, he is already burdened with his family issues. So now there's a doubt creating over here कि A might not be person who has killed B. ऐसा नहीं होना चाहिए. The circumstances must, everyone circumstance must be pointing towards the guilt only, nothing else. Because here, what the evidence is saying, कि maybe A might have not done something so severe with B. So these two things. Firstly, every incident, every circumstance must be put by the prosecution beyond reasonable doubt, and every circumstance must point out towards the guilt of the accused individually. This is all for the circumstantial evidence. Any problem now? Please remember this case, Sharad Vidyachan, very important case, and these two are the recent judgments that have been discussed by the court in this case, Prakash Nishad case. So there can be a question from circumstantial evidence, because now we have seen the CLAT or other exams are also asking the questions from CRPC and CPC. Is this clear? Then only I will move forward to the next issue. No one is responding. I will move on to the next issue only. So,
this Indrajit Das case, what happened in this case, ma'am?
In this case, the principles of Sharad Vidyachan were only reiterated. Nothing new was said. Nothing important was said. They only applied the case of Sharad Vidyachan principles, and they said yes, the principles were followed. Nothing else.
Okay.
Okay, so what was the last thing that you could hear me? Please just confirm. I was answering the doubt of someone. Was it answered in the
Yes,
case?
ma'am. Yes, ma'am.
Okay, so now continuing further, the next issue now comes the disclosure statement of the appellant. What happened in this case when the 6-year girl was murdered by the accused, as what was story that was framed, and she was cut into the pieces and dumped into the drain. So there was no one saw the incident. There was no direct evidence available, but only the disclosure statement of appellant could bring out the whole plot of the prosecution. मतलब जो appellant ने खुद से बोला उसी की basis से पूरी story frame हो पाई. So the question over here was कि there was a language barrier when the disclosure statement of the appellant was recorded.